What happens when a Hollywood icon walks into the Supreme Court not to perform but to defend the Constitution? When Chief Justice Roberts tries to shut him down and ends up quoting him in the final ruling. This isn't fiction. This is the true story of how Denzel Washington used a forgotten letter from James Madison and a quiet voice to reshape religious freedom in America's classrooms. And the most powerful moment, he never raised his voice. He just told the truth and let silence do the rest. If you believe courage doesn't have to be loud and freedom shouldn't have to hide, hit that subscribe button now. Drop a comment. Should students be allowed to wear their faith in school? And if this story moved you, share it. Someone you know needs to hear it, because sometimes the quietest defense changes everything. The case was barely on the docket when the murmurs began. Anderson v. Department of Education. A quiet 14-year-old girl from rural Kentucky suspended from her public middle school for wearing a small wooden cross around her neck. Not speaking, not preaching, just wearing. But that tiny cross had ignited a national firestorm. On one side stood constitutional purists defending the First Amendment's protection of free religious expression. On the other, advocates for a strict wall between church and state, arguing that public schools should be faith-neutral zones. Law professors weighed in on cable news. State officials dodged questions. Civil liberties groups filed amicus briefs. And then, out of nowhere, a name appeared on the docket that no one expected to see again. Denzel Washington. Yes, that Denzel, Oscar-winning actor, cultural icon, and more recently surprise architect of the Supreme Court's landmark ruling in Henderson v. Department of Justice, which had reshaped civil forfeiture law just 1 year earlier. Now he was back, this time not to fight for property rights but for something far more personal. The right of a child to quietly carry her faith into a classroom. Court insiders were stunned. Washington had submitted a 42-page amicus brief meticulously written, grounded in originalist theory and citing over 30 cases from American legal history, including some state court decisions not seen in law school textbooks for decades. More shocking still, the court had granted him oral argument time, a rare privilege, practically unheard of for an amicus. The headlines turned incredulous. Denzel's legal encore, Hollywood meets the High Court. Again. Is he playing lawyer, or is he one? But for those who remembered Henderson, the snickering didn't last long. Back then, Washington had walked into the marble chamber and calmly dismantled 2 centuries of precedent on civil forfeiture using nothing but historical evidence, a soft voice, and a paperback copy of the Constitution. When Chief Justice John Roberts tried to cut him down with a condescending jab, it had backfired. Washington hadn't just held his own, he had changed the law. Now the stakes were different. This wasn't about money or property. This was about conscience. And not just his. The courtroom was packed. Retired justices sat quietly in the back. Law clerks leaned forward. Journalists scribbled furiously. The tension was strange, not hostile, but expectant. Even the marble columns seemed to press in. Most of the public didn't know the full story behind the girl at the center of Anderson versus D.O. Her name was Rachel. She didn't protest, didn't stage a walkout. She simply wore a cross, a gift from her late grandmother, and was sent home with a disciplinary note that cited disruption of secular learning space. The school's justification was rooted in policy. The parents said it violated her rights. Lower courts had split down the middle. But the Supreme Court wasn't reviewing a dress code. They were about to reconsider what religious freedom means when it's worn, not shouted. And into that storm walked Denzel Washington, not in character, not in costume, not on a film set, but back at the Supreme Court lectern, brief in hand. Ready once again to challenge power with preparation. He wore a plain dark suit, no entourage, no fanfare, just a quiet determination. For the older generation watching on C-SPAN, it was surreal. Here was a man they'd seen deliver fiery speeches on screen, now standing before 9 justices in real life, calmly preparing to argue a point of law that could alter the way religion and education intersect for millions of students across the country. Chief Justice Roberts sat at the center of the bench, thumbing through Washington's brief. No opening smile this time, no warmth, just scrutiny. The courtroom whisper had grown into a national question. Can a cross be silent and still be disruptive? Can faith be too small to threaten, but too bold to ignore? And the bigger question, could Denzel Washington do it again? As the bailiff called the session to order and the justices entered, even veteran legal analysts couldn't predict what would happen next. But one thing was clear: this wasn't a sequel, it was a new battle, and America was watching. The chief didn't wait long. Just moments after Denzel Washington had opened his oral argument, calmly referencing Thomas Jefferson's Virginia Statute for Religious Freedom as a foundational lens to understand the First Amendment, Chief Justice John Roberts cut in. Voice sharp, eyebrow arched. "Mr. Washington," he said, "you speak of tradition, but are you confusing devotion with jurisprudence?" No one breathed. The room, just seconds before hanging on every word with hushed reverence, now felt colder. More alert. It was a classic Roberts maneuver, swift, cerebral, and public. And if you listened closely, it wasn't just a question. It was a challenge wrapped in condescension. Was Denzel just performing again? To the average viewer at home, the exchange might have passed as firm but fair. But for those who followed the court, especially Americans who lived through the Warren years, the Rehnquist shifts, and the Roberts era's balancing act, it was obvious what just happened. This wasn't about precedent. It was about testing the man, testing whether a man known for memorizing scripts could survive without one. Justice Sonia Sotomayor leaned slightly forward in her chair. Not aggressively, just enough to make eye contact with Roberts. A flicker of concern, maybe. Or maybe recognition. She'd seen that move before. So had many of the seniors watching from home. Justice Amy Coney Barrett, pen poised, slowed her note-taking. Not because she was skeptical, but because she could already sense that this wasn't going to be the standard oral argument. This wasn't going to follow script, because this man, Denzel Washington, wasn't here to play safe, and Roberts knew that. In hindsight, the interruption was strategic. In Roberts's long career, from Harvard Law Review to Solicitor General to Chief of the highest court, he had encountered brilliant minds, but also many who folded under the weight of early questioning. Break their rhythm, challenge their foundation, and if there's a crack, it'll widen. So when Denzel opened with Jefferson, that was Roberts's moment. Tradition, he snapped. Devotion, he was implying. Denzel had confused a spiritual commitment with constitutional clarity, that he was speaking from heart, not history. Roberts had underestimated the man standing at the podium. Washington didn't flinch. He didn't even glance down at his notes. Instead, he nodded slowly, folded his hands on the lectern, and answered in the same calm, measured tone he had opened with. "With respect, Chief Justice," he said, "the jurisprudence of religious liberty begins with the devotion that defined our founding debates. It's not sentiment, it's origin." He paused, let it land, then continued. "If I may, we often treat faith as a modern intruder in public life, but the record shows otherwise. The first laws of this nation did not separate God from government, they restrained government from defining God." A few heads in the gallery turned. A senior clerk in the third row scribbled faster. That wasn't the answer of a performer. It was the answer of someone who had read everything from the Madison Papers to the original drafts of the Northwest Ordinance. Roberts leaned back, not in defeat but in awareness. He'd come to probe. What he found was stone, But the tension hadn't broken. If anything, the exchange had raised the stakes. Everyone in the courtroom knew what was happening. Roberts was throwing the first punch, and Denzel had absorbed it without blinking. But now the question wasn't whether he'd survive. The question was, would he win the room again? Justice Kagan tilted her head ever so slightly. Her eyes were focused not on the notes, not on the argument, but on Washington himself. She'd seen hundreds of advocates stand in that spot. Some were passionate, some were scholarly, rarely both. And now this man who just 12 months ago had redefined civil forfeiture law was citing religious charters from 1786 with the precision of a constitutional scholar and the poise of a seasoned litigator. Still, the courtroom hadn't softened. No one was going to hand him a victory. The audience watching at home, especially those over 65, could feel that old courtroom electricity. That slow-building, high-stakes exchange where every word might become precedent. For viewers who had lived through Engel versus Vitale or Lee versus Weissman, the tension wasn't academic. It was generational. Because this wasn't about a necklace. This was about what kind of country their grandchildren would grow up in. Would a quiet cross around a child's neck be treated as disruption or dignity? As Denzel shifted gears back to his prepared remarks, the tempo changed. He wasn't rattled. He was rising, like a preacher who'd been momentarily interrupted but whose conviction only deepened. What's at stake in Anderson versus DOE, he continued, is not whether schools endorse religion. It's whether children must hide theirs to receive an equal education. That line stuck. It would later be replayed on cable news, quoted in op-eds, framed on law school walls. But in that moment, it was something more. It was a turning point. Even Roberts, silent now, didn't interrupt again. For the next 8 minutes, Washington laid the groundwork, historical context, legal precedent, and a steady return to the argument that the First Amendment protects not just belief but the visible, peaceful expression of it. And yet the courtroom still carried the tension from that first verbal blow. Roberts had struck early, but Washington had struck deeper. And in that grand, silent chamber beneath the flags, the seal and the stone, the battle lines had been drawn. This wasn't about the performer anymore. This was about the Constitution, and who truly understood it. And for millions of Americans watching from living rooms and veteran halls, nursing homes and kitchen tables, the question wasn't just whether Denzel would win. It was whether truth could still speak back to power and be heard. There was no delay, no stammer, no flicker of emotion. When Chief Justice Roberts tried to draw a line between devotion and jurisprudence, Denzel Washington didn't retreat. He turned the table calmly, deliberately, with history in one hand and the Constitution in the other. He reached down, unfolded a single sheet of parchment. Not a replica, but a certified facsimile from the Library of Congress. This, he said, is the Virginia Statute for Religious Freedom, drafted by Thomas Jefferson, passed in 1786. It didn't separate belief from public life. It protected belief from public power. The courtroom stilled. Justice Elena Kagan stopped writing and lifted her eyes, not out of doubt but out of curiosity. Something important was happening. Before the impact of the Jefferson statute had fully landed, Denzel placed a second sheet beside it, a smaller, more fragile page, aged, slightly curled, bearing the familiar tight script of James Madison. And this he continued, holding it gently, as a letter Madison wrote in 1791 to a schoolmaster from the Society of Friends. A Quaker. The school had allowed children to wear tokens of faith, simple crosses, thread-bound prayer beads, and yes, even hats. The principal had asked if this violated constitutional principles. Denzel looked straight at the bench. Madison replied, "Let the conscience breathe where the state dares not tread. A silent symbol is no more a sermon than a still candle is a flame." A low murmur rippled from the gallery, not one of surprise but recognition. He wasn't quoting movies now. He was quoting Madison's original hand. In that moment, the courtroom shifted. It wasn't just a debate anymore. It was a journey back to the founding table. For Americans over 65 watching on live broadcast or catching the replay later that evening, that moment was electric. They remembered when civics class included real parchment, when Jefferson and Madison weren't just trivia, they were the moral backbone of national memory. Now here was Denzel Washington, an actor, yes, but also a constitutional scholar in his own right, channeling those same voices in the very chamber they helped inspire. Justice Kagan leaned back, arms crossed, not dismissively but in active contemplation. Justice Thomas remained unreadable, but his gaze didn't break from the documents now displayed before him. Justice Barrett resumed writing, this time more slowly, eyes darting between Denzel and the original sources, and Denzel pressed forward gently but with purpose. We talk today as though the First Amendment protects only belief in private. But the record says otherwise. The founders feared a government imposing religion, yes, but they never feared a citizen quietly living it. He paused. There is no clause in this Constitution that demands a child hide her conscience to receive an education. That was the moment the silence in the chamber became reverent. No phones buzzed, no pens scratched, even the rustle of paper stopped. Because Denzel wasn't performing anymore, he was teaching, not with charisma, with command. He glanced down only briefly, then returned to the justices. The student in Anderson was not proselytizing. She wasn't disrupting the learning process. She wore a simple cross, a small wooden pendant on a leather thread, the same one her grandmother gave her before she passed away from cancer. She did not speak. She did not sing. She did not force belief. She simply remembered. At that, a visible shift took place among the older justices. Not sentimentality, reflection. This wasn't just about the law, it was about meaning. The idea that such a symbol threatens the neutrality of a school misunderstands neutrality itself, Denzel added. Neutrality is not the suppression of faith, it's the refusal to take sides. And if the state punishes a child for wearing her memory, her identity, her hope, it isn't neutral. It's hostile. In the gallery, a law professor from Georgetown sat frozen. She would later tell her students it was the cleanest articulation of passive faith expression I'd heard since West Virginia Werther's Barnett. And it came from Denzel Washington. But in real time, the moment was still unfolding. Justice Roberts, whose early interruption had set this entire sequence in motion, shifted in his chair but said nothing. His face now revealed less challenge, more concern. Had the court drawn its own compass off-center? And then Denzel closed the moment not with flourish but with clarity. The child's cross is not a message to others, it is a message to herself. The First Amendment was not written to shield others from her quiet courage, it was written to shield her from their fear of it. That line, quiet courage, would appear in editorials across the country the next day. In retirement homes, community centers, and veterans halls, it would spark conversations about prayer in school, respect across differences, and what it really means to live in a pluralistic republic. And in that courtroom, it marked the beginning of the real confrontation, not between Washington and Roberts, but between two definitions of liberty. The court had heard legal theory before. What it hadn't heard, at least not in this way, was a moral compass grounded in founding documents held up not to push an agenda but to point the nation back to its roots. Denzel didn't slam his notebook closed. He didn't raise his voice. He just stepped back from the documents, returned his hands to the lectern, and waited. For a full 5 seconds, the room said nothing. Then Justice Kagan broke the silence. "Mr. Washington, who sourced those letters for you?" For the first time that morning, a small smile touched his face. "I did. Archives of the Madison collection. Spent the better part of a year in those rooms. And just like that, the battle over a school cross had become a referendum on how deeply one man had studied the foundations of faith and freedom. It was no longer if the court would listen. The question now was how far would they follow the compass? The court was still absorbing the moment when Denzel Washington, standing just feet from the marble bench, lifted a second page from his folder. The air already taut from the Jefferson statute now felt heavier. But what he held next wasn't a statute. It was a letter more intimate, more personal. A letter from James Madison dated 1791, not a speech, not a law. A private reply to a school principal from a Quaker seminary concerned about allowing students to wear religious tokens in class. In that letter, Denzel said, raising it slightly, Madison writes, "Faith, when unforced, shapes virtue. It is not the state's to gift nor to erase." And just like that, the discussion pivoted. From legal precedent to founding intent, from abstract theory to moral clarity, the man known as the father of the Constitution had spoken across time into the very question now dividing the court. Justice Barrett leaned forward, not out of politeness but attentiveness. She more than most understood the weight of original intent. Justice Thomas closed his binder. He knew the document. But the way Washington framed it at that moment in that forum gave it new breath. Denzel didn't stop there. Madison wasn't making a public pronouncement, he explained. He wasn't shaping a campaign. He was answering a simple question: can a student's conscience have a place in the classroom? And his answer wasn't fearful, it wasn't bureaucratic, it was American. Let conscience breathe, let quiet symbols stand. This wasn't performance, it was persuasion. For viewers watching at home, especially those over 65, it felt familiar. Not just the names Madison and Jefferson, but the deeper conflict. The one many remembered from their own school days, morning prayers recited quietly, Bibles tucked into coat pockets, crosses worn beneath shirt collars. And then over decades, those gestures removed not by force but by fear of offense. And now here was Denzel Washington reminding the nation that the First Amendment was never about erasure. It was about protection. We often forget, he continued, that the First Amendment doesn't just shield us from government-imposed religion, it shields us from government-erased belief. He wasn't pleading. He wasn't posturing. He was inviting the justices to remember. Not just the law, but the principles behind it. And then came the line that would echo beyond the courtroom. The Constitution protects the right to believe and the right to wear that belief gently on your sleeve. No defiance, no shouting. Just quiet strength, a message tailored not for dominance but for dignity. Inside the chamber, the justices remained still but not disengaged. It was the kind of stillness that signals real listening, and perhaps for some rethinking. Denzel stepped away from the lectern for just a breath, then returned with one final point. If we say a child's necklace must be hidden for neutrality to exist, we are teaching the next generation that faith is a private embarrassment. That public life belongs only to those who believe in silence. He looked squarely at Chief Justice Roberts, whose earlier jab about confusing devotion with jurisprudence now hung awkwardly in the past. But faith, when personal, peaceful, and unforced, is not a disruption. It is a compass. That word landed hard. Compass. For decades, Americans had debated the place of religion in public spaces, in courtrooms, in courthouses, in classrooms. But rarely had the issue been framed so plainly, not as control or conflict, but as guidance. Quiet, inward, voluntary guidance. Something to be worn without shame. Justice Sotomayor whispered something to her clerk. Justice Kagan rested her chin on her hand, eyes fixed on the parchment in front of her. And the people watching at home. Men and women who had lived through school prayer bans, 10 Commandments removals, and cultural battles over nativity scenes sat in silence. not because they were shocked, but because they understood. This wasn't a radical argument, it was a reminder that the Constitution had room for belief not because it favored it, but because it respected it. In a time when shouting often replaced substance and outrage drowned out nuance, Washington had delivered a moment of stillness, a legal argument rooted not in noise but in heritage. And then, as if sensing the moment had reached its peak, he stepped back slightly, placed both hands on the lectern, and said nothing more. It was Roberts who finally broke the silence. "Thank you, Mr. Washington." The tone was different now, measured, respectful, even perhaps chastened. For a courtroom trained in centuries of precedent, the message was clear. This wasn't about whether faith belonged in government. It was about whether government had the authority to erase faith from those it governs, especially the youngest among us. Outside reporters gathered on the steps. Legal scholars exchanged hurried glances. Social media feeds lit up with the phrase, "The Constitution protects the right to wear belief gently on your sleeve." And in homes across America, especially among older viewers who had walked these cultural fault lines before, there was a renewed feeling that maybe, just maybe, the country still remembered what its compass pointed toward. And in that courtroom, thanks to one quiet voice with a letter from 1791, the needle had moved. The silence that followed Denzel Washington's reading of Madison's letter wasn't ordinary. It lingered not out of awkwardness, but out of weight. Something had landed, something that wasn't just legal, it was moral, historical, American, and then finally Justice Clarence Thomas spoke. His voice, low, calm, but cutting through the chamber like a plumb line, broke the quiet with a question as straightforward as it was. "Seismic, Mr. Washington, would your argument apply equally to a Jewish yarmulke or a Muslim hijab?" No gasps. No shifting in seats, just a pause. And then Denzel answered without missing a beat. "Precisely, Justice Thomas. Liberty is not granted piecemeal. It either respects all faiths or none." The sentence echoed not in volume but in resonance. For a court often accused of hair-splitting distinctions, Washington's answer was a sledgehammer, clean, direct, and impossible to dilute. Justice Thomas nodded ever so slightly. The originalist in him had heard what he needed: consistency. Not a defense of Christianity, but a defense of conscience. Every conscience. That's when the room truly shifted. Justice Amy Coney Barrett, with her sharp intellect and deep interest in religious liberty, leaned in and raised a more layered concern. "Mr. Washington," she asked carefully, "what about social pressure? If a child wears a cross or a yarmulke or a hijab, could that be seen as exerting influence over others, even unintentionally?" It was a fair question, rooted not in constitutional text but in the real-world dynamics of school life. Peer pressure, conformity, identity, but Denzel was ready. "Justice Barrett," he replied, "the difference lies in origin. When expression comes from the state, it carries force. When it comes from a child, it carries meaning. A visible symbol of faith worn quietly is not coercion, it's presence." He paused just long enough to let that distinction breathe. "If a student chooses to pray before lunch, we don't accuse her of trying to convert the cafeteria. If a child wears a Star of David necklace, we don't assume he's imposing doctrine. These aren't threats, they're threads woven into the fabric of pluralism." The justices were listening differently now, not just fact-checking, following. Justice Kagan, who had been focused intensely since the Madison quote, scribbled notes with a kind of urgency. Justice Sotomayor tapped her pen rhythmically, lost in thought. Even Chief Justice Roberts, who had once doubted whether Denzel understood the boundary between belief and law, now watched with a steady, measured gaze. The shift wasn't loud, it was internal. Washington had done what few courtroom advocates ever achieve. He had reframed the question. This wasn't about whether religion belonged in public schools. It was about whether students had the right to be whole, to carry their heritage, their grief, their hope into the classroom without shame. You cannot ask a child, Denzel said, to leave her faith at the school gate, and still ask her to bring her full self to the classroom. That line, "bring her full self to the classroom," would be quoted by educators, theologians, and civic leaders for months. Not because it was flashy, but because it told the truth simply. And for older Americans watching it cut to the core, they remembered the moments in their own childhoods when belief wasn't political, it was personal. A grandfather's rosary, a mother's Bible, a folded napkin prayer whispered before a test. These weren't acts of power, they were acts of grounding. Now, through Washington's voice, those memories were being revalidated in the highest courtroom in the land. Justice Barrett nodded thoughtfully and returned to her notes. The challenge had been answered not with rhetoric, but with clarity. Then, like a conductor sensing the shift in tempo, Denzel returned to the heart of his argument. The Constitution does not fear faith. It fears power that manipulates it. And what we see in this case is not a government trying to prevent domination, but a school policy so fearful of difference that it crushes expression. That is not neutrality. That is erasure. You could almost hear the recalibration happening in the room. Legal minds turning, parsing, shifting positions not just out of persuasion but out of realization. Because Washington had not simply defended one Christian student. He had defended the Sikh boy who wraps his hair in cloth, the Jewish girl who lights a candle each Friday, the Muslim student who whispers Bismillah before opening her math book. And for the justices, especially the ones who cared deeply about both constitutional integrity and cultural cohesion, that universality mattered. If we begin to say Denzel concluded that quiet symbols of private faith must be hidden, then we have not protected children from pressure. We have protected the system from diversity. In that moment, Anderson versus Department of Education was no longer about a cross. It was about whether freedom means fitting in or standing firm. For Roberts, it was a reckoning. For Thomas, it was affirmation. For Barrett, it was a bridge between principle and practice. And for the millions of Americans watching, especially seniors who had watched these legal tides shift over decades, it was clarity. Not outrage, not noise, clarity. As Denzel stepped back from the lectern, the room stayed quiet, not because it was stunned, but because it was processing. The shift had happened, not with a ruling, but with a realignment, from suspicion to respect, from scrutiny to understanding, from the courtroom to the country. For nearly an hour, Denzel Washington had stood his ground, calmly, methodically, and with a precision that turned heads and opened minds. What began as an early challenge from Chief Justice John Roberts had evolved into something far more compelling, a national reckoning with the meaning of religious liberty in the modern American classroom. By this point, Washington had quoted Jefferson, produced Madison's original letters, responded to Barrett's concerns about social pressure, and affirmed to Justice Thomas that true liberty is indivisible. And now, as the courtroom settled into its most reflective moment yet, the man who had first tried to dismiss Washington's voice finally leaned forward, not to rebut, but to inquire. "Mr. Washington," Roberts said, his tone now more measured, "how would you propose a standard that preserves both neutrality and freedom?" It wasn't just a question, it was a signal. The Chief Justice had moved intellectually, emotionally, and perhaps even constitutionally. He wasn't trying to trap Washington anymore. He was inviting him to shape the law, and Washington delivered. He didn't pause for effect. He didn't look down at notes. He simply raised 3 fingers and answered, not like an advocate grasping for relevance, but like a man who had thought this through long before stepping foot into the chamber. First, he said, any religious symbol, whether a cross, a hijab, or a yarmulke, must not disrupt academic instruction. If it draws attention beyond the person wearing it, that's a different conversation. But if it exists quietly and personally, it should be left in peace. A few nods. Second, he continued, the symbol must not be used to coerce or judge others. A necklace is not a sermon. A scarf is not a statement. Test is intention and impact. If the wearer is living their faith without imposing it, that's protected expression. Justice Kagan's pen moved steadily. Third, Denzel added, "We must draw a clear line between the state and the individual. Teachers, agents of the government, must be held to a different standard. But a student is not the state. When a child expresses belief, it is not endorsement. It is identity." With that, he lowered his hand. Silence. Not because there was confusion, but because there was clarity. Washington hadn't just answered Roberts, he had built a test, simple enough to apply across cases and principled enough to withstand the politics of the moment. In the gallery, a senior appellate judge whispered to his colleague, "That might end up in the syllabus, and in homes across America, especially among older viewers who remember when legal clarity was a civic virtue. This moment struck a deep, resonant chord. The idea wasn't radical. It was reasonable. It didn't pit faith against neutrality. It reconciled them. And that's when the shift in the room became unmistakable. Even Roberts, once skeptical, even condescending, now sat back in his chair, his hand resting against his chin, not in resistance, but in reflection. What Washington had proposed wasn't just a defense of one child's right to wear a wooden cross. It was a framework for every student in every public school across the United States, a blueprint that honored the First Amendment's dual protection of religion and governance. Mr. Washington, Justice Barrett said softly, "You're arguing that neutrality doesn't require erasure, that true freedom includes visibility so long as it doesn't demand conformity." Washington nodded. "Exactly, Your Honor. Our founders didn't ask believers to hide. They asked government to stand back." At that, a quiet ripple passed through the chamber, not of dissent, but of acceptance. Roberts glanced at his notes, then returned his gaze to Washington. "Thank you," he said. "That's helpful." It wasn't an admission, but it was acknowledgement, and it marked the turning point not just of the hearing, but possibly of the case. Outside, cameras flashed. Inside, something deeper clicked into place. Washington hadn't just persuaded a bench. He had elevated the conversation. The legal reporters in the back rows were already drafting headlines. Washington's three-part test could shape the future of faith in public schools, from Hollywood to constitutional architect again. But inside the courtroom, where marble met silence, the mood was something else entirely. Restraint, respect, even reverence. The Chief Justice, who once questioned whether Denzel understood the difference between devotion and jurisprudence, was now sketching notes on the very standard Denzel had just proposed. It was a different Roberts, not because he'd surrendered, but because he'd listened. And the room, it didn't cheer, it didn't erupt. That's not how Supreme Court hearings work. But there was a stillness that spoke volumes, because for once no one objected, no one interrupted. Even the most ideologically rigid justices didn't reach for counterpoints. Instead, they absorbed. As Denzel stepped back from the lectern, he said nothing more. His time was nearly done, but the impact was just beginning. And for viewers watching from armchairs in Ohio, coffee shops in Georgia, or veterans' halls in Nebraska, the question wasn't whether they'd witnessed a powerful argument. They had. The real question was whether the law, like the country, still had room for a child to wear a quiet cross without having to explain, apologize, or hide it. And in that courtroom, thanks to one man's calm voice and a simple three-part test, the answer seemed suddenly undeniably clearer. Sometimes freedom doesn't need a microphone, it just needs a standard, and today Denzel Washington gave it one. By the time Denzel Washington stepped down from the lectern, the room wasn't just quiet, it was still. Not out of politeness, out of something deeper. A sense that something meaningful had just happened. No grandstanding, no fireworks, just clarity anchored in the Constitution, delivered with humility and felt by everyone who heard it. The ripple effect was immediate. Within days, legal blogs and university forums dubbed it the Washington Standard. Professors at Yale, Notre Dame, and Howard rewrote their spring syllabi to include transcripts from Anderson versus Department of Education. First-year law students were assigned not just the briefs, but the oral arguments themselves. At Liberty University and UC Berkeley alike, two ideological poles of American academia students debated not whether Denzel had won, but how profoundly he had reframed the discussion around religious liberty in public schools. He hadn't created division. He'd carved a middle path. 30 days after the hearing, the Supreme Court released its opinion 6-3 in favor of Anderson. The language was strikingly direct, and the majority opinion, written by none other than Chief Justice John Roberts, made national headlines. Freedom of faith means nothing if it must be hidden to exist, Roberts wrote. In the American classroom, visibility of belief, when peaceful, personal, and voluntary, is not disruption. It is expression. He cited Washington's three-part framework, explicitly calling it a constitutionally sound standard that honors both the establishment and free exercise clauses. Legal scholars marveled not just at the decision's scope, but at its tone: measured, balanced, decisive. Roberts didn't just adopt the structure. He adopted the spirit of what Denzel had stood for. Justice Thomas, in a concurring opinion, went further, declaring that the First Amendment does not require cultural sanitization. It demands cultural tolerance. Meanwhile, Justice Barrett wrote a thoughtful concurrence underscoring the importance of distinguishing between institutional power and personal conviction. Even the dissent penned by Justice Alito acknowledged that Washington had presented a serious and historically grounded argument that merits future review. Outside the court, the decision was met not with protest but with reflection. School districts across the country quietly updated their policies using Washington's standard as a legal compass. Guidance counselors in Iowa, Tennessee, and Oregon were retrained. Teachers received new professional development workshops titled Expression versus Endorsement: Understanding the Line. It wasn't just about a necklace anymore. It was about a principle, a quiet right that millions of Americans had carried for generations, often without knowing whether it was still truly protected. And yet, while the media buzzed, Denzel Washington vanished from the spotlight. He turned down every interview request: CNN, Fox News, NPR. Not because he was hiding, because the work was done. Weeks passed, and eventually a local education reporter from a Virginia public radio station spotted him. Not at a gala, not in a lecture hall, but seated on a folding chair in the back row of a high school gym in Prince William County. It was a student-led forum on faith and education. No press, no staff, no speeches, just Denzel listening. One teacher present described it simply: he didn't speak once. He just listened, took notes, smiled when they shared stories. You could tell he wasn't there to be honored. He was there to understand. The image went viral anyway, a world-renowned actor, legal architect of a Supreme Court victory, quietly absorbing the voices of the students he had just empowered. A New York Times columnist summed it up best. He won not just the argument, but the trust of a generation searching for quiet courage. And they had found it. In a time when shouting often substitutes for substance, when outrage overshadows principle, and when media moments are choreographed for maximum clickbait. Denzel had taken a different path, one marked by preparation, restraint, and historical grounding. It resonated especially with older Americans, those who had watched the court evolve over decades, seen culture wars play out on classroom chalkboards and courthouse steps. For them, this moment didn't just feel like a legal victory, it felt like a moral reset. A reminder that some things, faith, respect, humility, can still be defended with dignity. In churches, Rotary meetings, and small-town diners, people quoted his words. A necklace is not a sermon. A scarf is not a statement. These aren't threats. They're threads. In one nursing home in Indiana, residents held a round table to discuss the ruling. Most of them hadn't felt energized by court news in years. It feels like America remembered something one veteran said, and it took an actor to do it. But those who followed Washington closely knew it wasn't about celebrity. It never was. It was about the Constitution, and the promise it holds, not just for the powerful, but for the student with a wooden cross, the boy with a yarmulke, the girl with a hijab, and every American who walks into a public space with quiet conviction in their heart. That's the legacy of Anderson v. Dio, not a courtroom battle won with noise but with clarity. Not a culture war fueled by outrage, but a constitutional standard rooted in common sense. And as the story faded from the headlines, something else remained, something deeper. A line written in the majority opinion that felt less like law and more like a national reminder. Freedom of faith means nothing if it must be hidden to exist. That truth, once buried beneath decades of bureaucratic caution, was finally brought into the light not by force but by quiet defense. And in the end, that was enough. In a time when shouting dominates headlines and anger drives attention, Denzel Washington reminded us that true strength often speaks in silence. His calm defense of a student's right to quietly wear a symbol of faith, based not on emotion but on history, law, and conscience, shows that dignity and preparation still matter. For those of us who've lived through civil rights battles, prayer bans, and shifting social norms, this case echoed something deeper. Freedom isn't freedom if it demands that we hide who we are. Our Constitution wasn't written to silence faith, it was written to protect it, especially when it's peaceful and personal. Denzel's three-part test wasn't just a legal solution. It was a moral compass. And maybe that's what we need more of today. Fewer slogans, more substance. Fewer assumptions, more understanding. Let this story be a reminder. You don't have to be loud to be heard. You just have to be grounded in something that lasts. If this story resonates with you, let us know in the comments. Have you ever felt pressure to hide your values? Hit subscribe to hear more stories where truth, not volume, carries the day. And share this with someone who still believes in quiet courage.